seems to be under the impression that the court has now changed its ruling and that we are not allowed in our opening statement to address the idea, which the court previously ruled we could, that we did not find out about this defense until the 20th. The court had said previously, on the record, yes, Mr. Lewin, you guys can address that issue in opening. I will decide whether I'm going to issue a discovery instruction later. Counsel believes you've now said we can't do that.
I did say that.
Yesterday, yeah.
I did. I had said yesterday that the purpose for an opening statement is to give the jury an idea of what the evidence, what you believe the evidence will show. Talking about late discovery, that's argument. So as far as your opening statement, I don't want you to mention anything about you just found out about a starter pistol. That is not part of what the evidence will disclose. I talked about that yesterday.
So, Your Honor, but I am correct. The court's original ruling was...
Yeah, that is right. I said, originally, I said, yes, you can bring it up.
Okay.
But then after thinking about it, that's not part of an opening statement. So I don't want you touching it.
Okay, understood.
Go on with the present issue about the ballistic.
So where we sit right now is that counsel is arguing two inconsistent positions. They're arguing that this evidence is so damaging that we have to start over. Now, that's not in a vacuum. It's very clear that the defense is not happy with this jury. They've made it clear.
Hold on.
No. Don't interrupt.
Okay.
He didn't interrupt you. Don't interrupt him.
It is very clear by the comments the defense has made in court where they have repeatedly said that their client is not getting a fair trial because of what they believe is the composition of the jury, the fact that they have filed a writ, the fact that they have continued to bring this up, leads to the inescapable conclusion that what they are looking for is a way to start over. I believe, Your Honor, that what we have proposed is more than fair because in the end, Your Honor, they're arguing it both ways. As the court mentioned before I ever pointed out, they're arguing, if you let this in, Judge, my client can't get a fair trial. Oh, by the way, what's the value of this anyway? What does it matter? Again, my position would be the second argument is inaccurate. It is evidence that is helpful to our case. It doesn't prove the case by itself, but it is definitely helpful. It is not irrelevant. It's not 352.
All right. You don't have to go on.
Okay.
I believe I have enough information to make a decision.
All right, please on.
No, you can't.
I can't respond to what he just said about the jury.
It doesn't matter about what he said about the jury. That has stop. That has no bearing on any decision I'm going to make.
There's a record, though. There was a record.
I don't believe that you are unhappy with the jury. Mr. Lewin might say you're unhappy with the jury, but I don't believe you are. If you were, you wouldn't have accepted the jury. I believe that both sides are satisfied with this jury and that both sides will get a fair trial. You don't need to respond to it because it doesn't matter whether he does or does not think you're happy with the jury. I believe that you are satisfied with the jury. All right, here's the way I want to deal with the latest, recently finding out about this ballistic report. Everybody at the table, all counsel, to me, has great credibility. I accept what all of you say. I don't believe that there's been any nefarious conduct by anybody. If this late report involved, all of a sudden it was disclosed that a witness, an additional witness positively identified Mr. Mayers as the shooter, that would be very critical and crucial. If a witness came forward and said, yeah, Mr. Mayers confessed to me that he shot ASAP Relly, that would be very critical and crucial. If a firearm, if a 9mm was recovered, that could be ballistically compared to the casings, and that just became discoverable or became disclosed, I think that would be critical. But that is not what happened here. What I'm seeing here is that the casings that were recovered were examined, and the opinion is they could have been fired from a Glock 43 or any other number of types of 9mm. You have said that, well, now you want to hire a ballistic expert. That's not fair to you and your client. So this is what I am proposing. We have a list, a Superior Court list of firearm examiners that have been recognized as experts. My star judicial assistant over there, Alice, will print out that list. Ms. Kaplan is an attorney who practices in this area. If there is someone on the list that you want to hire, contact that person and tell them this is crucial that the ballistic evidence be examined now. Not later, but now. The court will pay for it. Mr. Mayers will not have to pay for this. We will. If the firearms examiner wants extra money because it's a rush, the court will pay for it. If you are not satisfied with the people on the list, then if you want to find your own examiner who will do the examination, the court will pay for it. If it's necessary that I speak to the examiner to impress upon the examiner the importance of getting this done ASAP, I'm glad to do that. I am providing my cell phone number to all of you. If you need to call me any time of the day or night, I will speak to you. I will speak to a firearms examiner. If you feel it is necessary, Mr. Tacopina, we can be dark on Monday. But I'm not excluding the evidence. I don't find that there is any nefarious conduct. The evidence is relevant. It's not a smoking gun, but it is somewhat inculpatory. But in and of itself does not mean that your client is guilty. That's the way we're going to deal with this, and that's the final ruling. I don't want to hear anything more about it. That's the end of the issue for now. Are both sides ready for the jury to come in? Do not mention anything about the ballistic comparison in the opening statement.
That was our question.
So,
Yeah, do not mention that.
Understood.
Your Honor, what I was planning on mentioning was that the cartridges found at scene were 9mm. In the defendant's house was a magazine that was 9mm.
All right.
And had some 9mm live ammunition in it. That was it.
If that has been part of the discovery and that was known, then that's fair game.
Yes.
But this ballistic comparison, that's off limits
Correct.
for the opening statement.
Yes.
Understood.
All right, bring the jury.
So bring the jury and I'll print the list for the.
Oh, yeah. Do you want that, Ms. Kaplan, the list of the firearms examiners?
I could also email it.